I think it's finally about time we go over what exactly happened with the CCFR's court case at the Federal Court of Appeal, and why I think we're about to win big and have these unlawful OIC gun bans overturned. Let's have a look. Now, quick heads up here before we get started. This is mostly going to be a talking head video with not much visual information on screen. So if you want to tab out and just listen to it in the background while you're on the go or doing other things, that may be the best way to enjoy this content. Welcome back to the channel. So today we're going to be continuing our CCFR versus Canada series. Up until now in the series, we have focused solely on the negative rulings handed down by Injustice Kane after the judicial review at the federal court. But from here on out in the series, things will be a bit different. As many of you already know, the CCFR and the other applicants pretty heavily disagreed with Injustice Kane's ruling, and as such, they filed for an appeal of her faulty ruling. That appeal was granted, and so the applicants went back to court on December 9th and 10th at the Federal Court of Appeal in Ottawa. So for today's video, I'm going to be summarizing and explaining what exactly transpired at the Federal Court of Appeal for those who didn't watch it live, as well as why I think there is sufficient reason to believe that we're going to win, and win big, this time around. But first things first, I think it's important that you understand what the point of the appeal process is. In an appeal, the applicants aren't exactly just given another opportunity to make their case. More specifically, the applicants are also there to demonstrate why they believe their previous justice erred in his or her decision. And in this instance, that Injustice Kane erred in her ruling as a matter of her interpretation and application of the law. And as such, this means that they generally cannot bring new evidence to the table, which makes sense. Like, it wouldn't be a sensible argument for the applicants to file for an appeal on the basis that Injustice Kane made some kind of mistake, only for them to turn around and present a bunch of information that wasn't actually available to Injustice Kane when she made her ruling. However, within the confines of the evidence and the angles which were discussed at Kane's review, the applicants are permitted, and even expected, to reiterate and evolve their arguments in response to the various criticisms and interpretations which Kane handed down in her ruling. And a quick reminder for everyone before we get started here, these court proceedings are something called a judicial review. And in a judicial review, the applicants must typically demonstrate that the respondent acted unreasonably. However, when it comes to some specific areas such as constitutional questions, the applicants must prove that the respondent acted incorrectly. The respondent in this case is the Government of Canada, as represented by the Attorney General of Canada. So the CCFR and other applicants are taking the position that the government acted unreasonably in a number of different ways regarding the 2020 Order in Council, which saw the banning of over 1,500 models of so-called assault-style firearms. So the question before the court isn't really a matter of right or wrong exactly, or if our interpretation is better than the government's interpretation. It's simply a matter of reasonable or unreasonable. Does the government's interpretation and application of their powers fall within a range of reasonable interpretations and options available to them? If it does, then the decision is reasonable and we lose. And of course, the government is owed deference for their actions, which essentially means that the government is sort of innocent until proven guilty, and their actions are presumed reasonable until it is demonstrated otherwise. So as you might imagine, that places a pretty high burden of proof on the applicants. However, as I've demonstrated so far in the series, the CCFR and other applicants also have a legitimately strong case here. Now, you don't need to know the ins and outs and all the specifics of reasonableness before we start, as I'll be explaining them as we go, as they become relevant to our discussion here. But the current standard of reasonableness can be found in the Supreme Court precedent of Canada versus Vagueness. So anything stated in Vagueness is to be considered as the guiding principles of reasonableness. With that being said, let's get into it. At the Federal Court of Appeal, things are a bit different. Instead of just having one justice, we now have a panel of 3. And this helps insulate us from a single bad interpretation from ruining our case, as we saw happen with Injustice Kane. Now, a lot of you in the comment sections from previous videos in this series took her bad ruling to mean that she was a corruptly appointed judge put there by Justin Trudeau, but for what it's worth, that's not actually true. She was appointed by Stephen Harper in 2012. So to prevent such incorrect accusations from being levied again this time around, I want to introduce you to our 3 justices at the Federal Court of Appeal, as well as when they were appointed and who they were appointed by. So first up, we have the Honorable David Stratus. He was appointed to the Federal Court of Appeal by Harper's government in 2009, and then he also served as acting Chief Justice for a few months in 2023 after the previous one retired and before the current one was appointed. Now, I liked Justice Stratus during the hearing for a number of reasons, but in particular, he didn't much like the idea that the government was being so secretive about a lot of their points. Too often the government's lawyers relied on a just trust us bro justification for their rationale, and after a while, Justice Stratus really wasn't having any of it. And I think he, more than the other justices, also made a point of asking significant questions regarding most of the precedents which were being brought up and throughout, and tended to be a greater stickler on the details as to the exact phrasing of what the lawyers from both sides were saying. Now, I'll get into more of that as we go, but he seemed like a fairly level-headed guy for the most part. Next up, we have the Honorable Anne Mactavish. She was appointed to the Federal Court of Appeal by Trudeau's government in 2019. However, she began her career as a judge at the federal court in 2003, receiving 2 separate appointments in rather short succession from the Liberal governments led by Jean Chrétien and Paul Martin. Despite having one of the most badass names I've ever heard, I really didn't like what I saw from her during the hearing. On the first day, all 3 justices were pretty critical of the applicants, but on day 2, it felt like only the other 2 justices were equally critical of the respondents. And it seemed rather obvious to me that Mactavish clearly had her kid gloves on for day 2. And there were also other times where her biases were on clear display. Like, I really couldn't get a read one way or the other of how our other 2 justices felt about firearms or firearms owners, but it seemed abundantly clear by Mactavish's questions and her demeanor that she was fairly anti-gun. Now, for what it's worth, that's not even necessarily a bad thing. Like, everyone has their own biases, whether they're aware of them or not, but here it really felt like she had already concluded what she thought about the case before the lawyers even had a chance to make their arguments. Like, even if the other justices were anti-gun, which they may or may not be, like, I really don't know, there was really no indication to me that they allowed any such preconceptions to influence their behavior in court. So because of all that, I sincerely doubt that Mactavish will rule in our favor on any of the big points, but I'll explain why I think that in better detail later on. And lastly, we have the Honorable Yves de Montagny, who also happens to be the Chief Justice of the Federal Court of Appeal. Like Mactavish, Montagny received multiple appointments over the years, but unlike Mactavish, his come from both sides of the political spectrum. His initial appointment was from the Liberals and Paul Martin to the federal court in 2004, but he received his next appointment just 2 years later by Stephen Harper in 2006. Harper then appointed him to the Federal Court of Appeal in 2015, and after 8 years, Justin Trudeau then appointed him as Chief Justice of the Federal Court of Appeal in late 2023. Now, at the hearing, Montagny was tough, but he was also fair. In the first half of day 1, his questions to the lawyers of the CCFR and the other applicants were pretty brutal, almost to the point where one might consider it an interrogation. However, on day 2, he was equally rough with the government's lawyers, and I think as much as anything, that's what caused much of the government's case to fall apart. The applicants' cases were much better equipped to stand up to this harsh scrutiny, whereas the government's case simply was not. And this was particularly evident when it came to the ultra-vires discussion regarding the OIC powers found in Section 117.15 of the Criminal Code, but more on that later. And for what it's worth, I think it's a real shame that we even have to bring this kind of stuff up nowadays. Like, justices really should be appointed by merit and not by political affiliation. And frankly, it may even be that that is still the case and they are solely appointed by merit, but ultimately whether you think that comes down to a matter of trust in the Governor General and Cabinet, since they are the ones who actually do the appointing. And I think it's pretty fair to say that there is so little faith in those institutions nowadays, such that anyone they appoint is automatically suspect as well. Now, this is not an issue limited only recently to Trudeau or only to the Liberals, but they really put it on full display in the last 10 years here. A justice of the court really should be an independent individual whose integrity is just beyond question. But due to the nature of how they received the job in the first place, there is no way for such a claim to ever be true unless the integrity of the government is also beyond reproach. To which I say, good luck figuring how to work that one out. Okay, enough setup. Time to discuss the hearing itself. The hearing happened across 2 days on the 9th and 10th of December, and the format was pretty straightforward. On day 1, the CCFR and other applicants presented their case as to why they believed Injustice Kane erred in her decision, and as to why they believe they are right about their positions, and then most of day 2 belonged to the government's lawyers, but in the final hour of day 2, the applicants were presented with a few minutes each to have a rebuttal to respond to the government's points. Each of the applicants had roughly an hour or so to present their respective cases, with the exception of the intervenors who only had about 15 minutes each. And then between each presentation, there was a somewhat informal 15 to 20 minute recess before the next party got up to present their arguments. Now, due to how much information there is to go over from each applicant and respondent, this is not going to be an exhaustive look at the hearing. I'm only going to be spending a few minutes talking about each lawyer and their more salient points. Now, these are going to be the things that I think are the most impactful takeaways from each party, both the good and the bad, to show why I think we're going to win big whenever the Federal Court of Appeal finally hands down their ruling. And in particular, why I think we're going to win regarding the claims of the Vires and Vagueness, as well as the unlawful subdelegation of authority to the RCMP's Specialized Firearms Support Service for Firearms Classification, also known as the Firearms Reference Table. And of course, it bears repeating, but I am no lawyer. Nothing in this video or on this channel should be considered as legal advice. The views and interpretations I'm about to express should be understood merely as an opinion of people and events, not as some indisputable record of fact. And on top of that, I watched the hearing remotely through an online link, as many of you may have also done, and part of the agreement to watching this online was that we were not allowed to record their broadcast or take any screenshots of it or copies of the transcript. As such, I'm going to be deliberately paraphrasing a lot of what was said because I'm not certain that I won't be able to directly quote the things that were said by the various parties throughout this process. So everything I'm about to present to you regarding what transpired at court should be considered little more than hearsay. So, here we go. Day one started off with the CCFR's application being represented by Sarah Miller. She started off by telling everyone that she was feeling rather sick that day, which isn't important to her case exactly, but it is important for the context of what happens next. Miller and the CCFR were given an hour to present their appeal, and Miller jumped right on in, covering most of the issues which were presented the first time around to Injustice Kane. Most notably, she spoke to the vagueness of the word variant in the Order in Council, as well as the misuse of the Order in Council powers in Section 117.15 of the Criminal Code, otherwise known as ultra vires. Ultra vires meaning that the government acted beyond the scope of their authority granted to them by the law. If you want to learn more about the exact details of these arguments, please check out previous episodes in this series. Now, for the most part, the CCFR's arguments didn't appear to change much between Injustice Kane's review and their presentation at appeal. Like I said before, they can't present new evidence or arguments, but the way they present their arguments can evolve. And they should evolve. If you merely present the exact same arguments in the exact same way without attempting to clear up any of the misunderstandings or faulty rulings laid down by the previous judge, then it's reasonable to believe that you should expect the same faulty ruling a second time on your appeal. So in some ways it was a little unfortunate to see her do that. However, one way she did evolve the CCFR's argument was actually kind of cool, at least cool for me anyway. Fairly on in her presentation, Miller dove into the ultra vires use of the OIC powers found in Section 117.15 of the Criminal Code, and she started off by reading the statute for the court as a reminder. And for you guys as well, this is what that statute actually says. So Section 117.15 of the Criminal Code is broken down into two parts. Subsection 1 says, subject to subsection 2, the governor in council may make regulations prescribing anything that by this part is to be or may be prescribed. So that's the statute that actually gives them the power to ban things. And then subsection 2 says, in making regulations, the governor and council may not prescribe anything to be a prohibited firearm if, in the opinion of the governor and council, the thing to be prescribed is reasonable for use in Canada for hunting or sporting purposes. So effectively, subsection 1 says that the governor and council may ban firearms through an order in council, but then subsection 2 says that the governor and council is not permitted to ban firearms and other things which are reasonable for use in hunting or sport. The ultra vires argument is essentially that the firearms which were banned are in fact reasonable for hunting or sporting purposes, and therefore could not have been banned by the authority that was found in this statute. However, the government asserts that these firearms are unreasonable for hunting or sporting purposes because of the threat posed by these hunting and sporting firearms to public safety. So the legal dispute here is a difference of what the statute intended. Does reasonable mean reasonable in the context of hunting and sporting, or does reasonable mean in the context of public safety? The CCFR's argument initially used during Injustice Kane's review was that if the intent of the statute was truly about public safety, then the statute would have specifically mentioned public safety rather than what it actually says, which is reasonable for hunting or sporting purposes. And while that argument is certainly correct, I don't think it's particularly persuasive. In my previous video in this series, I spent a half hour explaining all the ins and outs of that discussion if you want to learn more about it, but the punchline to that video is that if public safety is truly the intent of subsection 2, then subsection 2 offers no restriction to the powers on subsection 1, and yet it is very clearly labeled as a restriction. And this is the cool part. Miller actually ended up saying that fairly early on as a part of her proceedings. She still said that the statute would have been drafted differently, but then she also very specifically said that if public safety was the only concern of the statute, then subsection 2 would not have been imposed at all. Which was pretty awesome to hear. Like, I don't know if her or the CCFR watched my video and then decided to adopt the reasoning themselves, or if they just looked back on how Injustice Kane ruled and then came to the same conclusion I did, but whatever the case, it was pretty neat to hear something I was saying come out of the mouths of a very intelligent and professional lawyer in a courtroom at the Federal Court of Appeal. Now, the downside here is that she only said it once. She did have a lot of things to discuss and only an hour to do it in, but I really felt like that's the core point to drive home here if you want to win on the ultra-vires argument. And the way she presented it felt mostly like an afterthought. But there was also another very significant problem during Miller's presentation, which no other lawyer really had to deal with. She went first. And by going first, she had to deal with the overeagerness of the judges. Now, I do want to say, I was actually really pleasantly surprised by how well informed our 3 judges were coming into the hearing. Like, they had an extremely nuanced understanding of the evidence and the ruling handed down from Injustice Kane's judicial review. Of course, I expected them to be familiar with the case generally, but all throughout the 2-day hearing, they were very often quoting hyper-specific things that Kane had said in her ruling, or quoting information directly from the res and bringing up questions about the previous evidence submitted and so on, and often this happened without them even being directed to it by the applicants or the respondents. However, that was also something of a double-edged sword. This wealth of knowledge also came with some burning questions they needed to have resolved, especially as it related to the fact that the applicants were disputing Injustice Kane's ruling. And Miller had to face that head on. It felt like every couple of minutes during her presentation, she was being interrupted by a cacophony of questions. I mean, which the judges are allowed to do. Like, they're supposed to be asking these questions, but the volume to which they were being asked, I think, was really throwing Miller off. Now, she stayed calm and cool and collected throughout the ordeal, but it made it really hard for her to get any traction and present any of her arguments fully. And given that she only had an hour to present her arguments, that really doesn't leave a lot of extra wiggle room for too many interruptions. Like, it even got to a point about 2/3 of the way through her time where she realized she was no longer going to have the time to present all of the arguments she wanted to, and she ended up just skipping like a good chunk of her script in her binder in order to attempt to address the myriad of questions being levied at her. You top that off with her being sick, and it was something of a perfect storm. Like, she didn't do a bad job by any means, don't get me wrong, but I think she wasn't as persuasive as she could have been to the judges. And I think the judges themselves were as much to blame for it as anything. Instead of allowing her to present her case to them as she saw fit, they really ended up steering her presentation to where they wanted it to go. So in effect, Miller was basically ambushed by our 3 justices just straight out the gate. And I think this hampered her ability to be as convincing as she could have been. And I think the justices themselves noticed this because they were not anywhere near as invasive for the other parties during the rest of the hearing. It felt like after they went in during that first break, they went into chambers and acknowledged that they were being too overbearing and that maybe they should probably take a step back a little bit. But to be fair to the justices, it's not like they were asking inappropriate questions. For example, all of the judges were asking this, but one of the things that Miller brought up, and most of the applicants brought up, is the fact that the government isn't being transparent in their reasoning as to what led them to the formation of their opinion that these assault-style firearms should be banned in the first place. The government made all of this information confidential under Section 39 of the Canada Evidence Act. However, Justice Mactavish was rather insistent that the opinion was very clearly formed and demonstrated within the res itself, and it frequently referred to these assault-style firearms of military design which are unsuitable for civilian use due to the inherent danger they pose to the public. And then Miller pointed out that there really isn't any such thing as a military firearm, which Mactavish appeared rather unreceptive to. But also that there were tons of firearms on the list which were not and have not ever seen any military use anywhere, ever. In particular, Miller pointed to the Robinson's Arms XCR rifle, which was designed specifically and intentionally to be used by civilians for hunting and sporting purposes. And this aligned with their non-restricted classification. She also mentioned the CZ550 that was on the ban list, which is a bolt-action rifle. And despite that, these were somehow banned as military-style firearms, which were somehow a threat to public safety, so the reasoning doesn't really add up. And then Justice Stratus was particularly insistent on wanting to know why the words reasonable for hunting or sporting couldn't be held to mean reasonable for hunting in light of public safety concerns. Why should section 117.15 subsection 2 of the Criminal Code be held to a different standard than the rest of the Criminal Code? Like, after all, it was established by Injustice Kane that public safety is the overall goal of the Criminal Code, so then why should this statute be any different? And that's a fair question. Miller responded by saying that the test for the purpose of the statute lies within the statute itself, which is not to be ignored in favor of its governing act, and that this very statute doesn't permit public safety concerns to trump the restriction that is laid out in the statute, otherwise subsection 2 would offer no real restriction. And while she was attempting to explain her answers, Chief Justice Montagny interrupted and wanted to know why it would be inappropriate for the Governing Council to consider public safety as a valid issue. After all, Cabinet sits at the apex of the executive in the Canadian government, and their discretion on all sorts of issues is typically quite broad, which is something of an ineffectual answer. Even though it is correct, it doesn't exactly answer the question. And this was something that the judges stayed stuck on until the fourth lawyer of the day, when Mr. Bouchelev was asked this question. And Miller had to go round and round on this stuff rather than being permitted to present her arguments in a controlled manner, as she may have intended. Miller also spent a fair amount of time trying to get the justices to understand the difference between reasonable for use and necessary for use, but that argument appeared to fall on mostly deaf ears so early on in the day. And even though the justices agreed with it, their questions indicated they didn't really understand it. However, the other applicants brought it up, including Mr. Bouchelev and Mrs. Generoux, so at least by the end of the day, the justices finally seemed to get on board with a lot of that. So, all in all, I think Miller actually did a pretty good job. But being so early in the day, being sick, and then having to deal with these overzealous judges, I think all of that impacted her overall effectiveness in a negative manner. She said a lot of good things, and she spoke to a lot more than what I'm covering here, but I felt like a lot of it was lost on the judges. She didn't end up being as persuasive as she maybe could have been. As an observer, as well as something of a rookie in spectating an appeal court, I really felt like based on the behavior of the judges, that they had already made up their mind regarding most of the points, and that we were going to be railroaded into another negative ruling from the judges who had already decided that some firearms are just too dangerous for the civilians to have, and it doesn't matter what the law says because nothing trumps public safety. Now, spoiler alert here, that's not exactly what was actually happening, and there is a light at the end of the tunnel. However, that doesn't become apparent until day 2. The Eichenberg applicants were up next, and they were being represented by 2 different lawyers who were presenting different aspects of their case. First out of the gate was Eugene Meehan, and it felt like he really picked up on the negative disposition that was being displayed by the judges. So, one of the first things he said was to serve as a reminder to them more than anything directly beneficial to his case. Basically, the first thing that he said after introductions was that he reminded the judges that this case really isn't about firearms at all, but rather it's an issue of authority. Firearms happen to be the topic at hand, but the legal questions to be answered are basically irrelevant to the issue of firearms themselves. The legal question is one of authority. Does the state have the authority to do what they're doing or not? Even if the government's intentions were pure, and even if their policies were effective, those questions are basically irrelevant to the court in a reasonableness review because the questions they should be answering lies within the boundaries of whether or not they have the authority to do any of that in the first place. Now, I do want to take a moment to say something about Eugene Meehan here. For those who watched the hearing remotely like I did, I'm sure a lot of you will likely agree with this. Eugene Meehan was the older, charismatic Scottish fellow who presented early on day 1. And this guy was an absolute stud. He gets my unofficial Chad Lawyer Award for the hearing. With the exception of Christine Generoux and maybe Sarah Miller, I felt like every other lawyer in this 2-day hearing appeared to be kind of intimidated by the court, including the government's own lawyers too. Nearly everyone was timid, nervous, and their voices were shaky, and their presentations had a good amount of awkward like ums and uhs and whatever else. But Meehan was the exact opposite of that. He was out here behaving like he belonged in that courtroom, and it showed. When the judges would ask him questions, Meehan would often converse with them as if they were his peers, and then when he was otherwise presenting his case, he did so as if he were giving a lecture and the judges were his students. And given Meehan's resume, that actually kind of makes sense since he did spend 8 years as a law professor at the University of Alberta. So he was articulate, concise, and had a presence in the courtroom not matched by any other lawyer there. He was out there just oozing with gravitas. It was quite the spectacle, which was good to see, because ultimately it didn't appear to make much of a difference to the negative disposition that I thought we were seeing from the judges. Despite his charismatic and convincing demeanor, the judges still engaged in rather robust discourse with him and appeared to be rather resistant to basically everything he was saying. Meehan also had to share his hour with his colleague Thomas Slade, so he didn't get as much time to present his case, but he sure made good use of every second he had. Meehan touched base on a number of issues, but primarily he spoke to the issues surrounding the vagueness of the word variant, and therefore also the unlawful subdelegation of authority to the RCMP. If you want to learn more about this issue, some parts of episode 1 and 2 in the series dive into it fairly well, but the argument goes a little something like this. The Order in Council specifies that some firearms are to be prohibited, as well as any variants or modified versions of them. But there is no lawful definition for what constitutes a variant. And without a definition, the application of the word variant changes on a whim, and it's often used in contradictory ways. And this leads to an area of uncertainty for us firearms owners and for manufacturers as well, who could be making every honest attempt to comply with the law and to not own any variants of banned firearms and to not make any variants of banned firearms. But since there's no definitive way to prove what a variant is or isn't without any definition, there is also no way to guarantee that individuals could not accidentally find themselves in violation of the law. Now, most people know that ignorance of the law does not make you innocent of a violation of the law, but if it's not actually possible to know what the law is, then that's a fundamentally unjust violation of your liberty under Section 7 of the Charter on the grounds of vagueness. And the government claims that this is okay, and that it's not vague, because the RCMP manages the firearms reference table, and that these variants will be declared there. But then that means that the RCMP is now the ones responsible for prescribing variants as prohibited, or more specifically, the specialized firearms support services that exist within the RCMP. And this results in an unlawful subdelegation of authority. The RCMP isn't allowed to be writing their own regulations and then enforcing those regulations. This is where the government, as well as Justice Kane and Justice Mactavish, it seems, become rather adamant that this is somehow still okay because the firearms reference table is just the opinion of the RCMP, therefore it's not actually law. The definitions in the criminal code, and therefore the courts, ultimately decide what is a variant or not, and there is precedent in Henderson which shows that the courts can overrule the firearms reference table. This means that the firearms reference table is not legally binding. But if that's true, then how does it actually serve to protect us from the vagueness issue? And this leads to a sort of chicken and the egg scenario of circular reasoning, which is something that most applicants argued one way or another during this hearing. So Meehan demonstrated that you can't really consider the firearms reference table to not be legally binding, as the firearms reference table can lead to people being charged with a crime, and he even further provided an example where the firearms reference table was referred to as proof during criminal proceedings. And this, among a great many other things he said, showed the judges that there was such an unlawful subdelegation of authority being had. But Meehan didn't stop there. He also went on to explain why the vagueness of the word variant was unreasonable and also completely unnecessary. Most of the other applicants were arguing that the word variant is too vague and therefore it shouldn't be used, or at the very least that it should be read down to named variants only. But that argument creates other issues for the government, and honestly, I think it's kind of too ambitious to expect the court to buy into that argument. And our judges pointed it out many times during Miller's and Meehan's presentations. They repeatedly observed that without the word variant, or if it were to be read down to named variants only, then the list would have to be updated multiple times a month, resulting in an unreasonable amount of work for the government. To which I say tough cookies. If they don't like it, then they should write better laws. And that's essentially what Meehan said as well. But then Meehan also had a slightly different take. The issue wasn't necessarily that the word variant was being used, but rather the issue was solely that the word variant remained undefined in the law. The only real issue that he presented is that we couldn't know what a variant was, not whether or not something could ever be a variant. So, he proposed a compromise. Put the OIC on hold and give the government, 6 months, 9 months, a year, whatever the court deemed appropriate, but give the government time to come up with a concrete definition. If a definition could not be decided upon that deadline, then the word variant could be stripped. But he also said that such a thing really shouldn't be that difficult. He provided many examples of far more complicated things that the law has had to define over the years, which it was able to deal with. Meehan even said that he could have a definition of the word variant drafted over lunch if they wanted. and that the government has plenty of capable and well-paid lawyers to do this drafting for them if need be. So therefore, there really isn't any good reason a definition shouldn't be able to be generated. And I think this is a far more palatable outcome for the judges than a binary yes or no to the use of the word variant. However, the judges expressed a fair amount of misgivings over requiring any kind of definition for the word variant. The judges seemed rather convinced that the inconvenience of having to define the word variant, or of not having to use it at all, somehow made the vagueness okay. And the judges often asked questions to this effect. The questions often implied that the benefit of the government being able to remain flexible was the intention of leaving the word variant undefined. But Meehan was rather adamant that the vagueness was impermissible, and that any and all issues related to overcoming this vagueness was solely the responsibility of the government to solve. Convenience is no justification for vagueness, and I think he's right about that. So, all in all, I actually quite like Meehan's presentation, and I think the judges will look favorably on this suggestion. However, he sort of tripped at the finish line. After a good 20 minutes or so of his presentation, he was finishing up and getting ready to sit down when he was asked, again by Justice Stratus if I recall correctly, if he had any opinion on the interpretation of reasonable for hunting or sport, and why that couldn't mean reasonable in the context of public safety concerns. And Meehan simply said that that wasn't a part of the arguments for his client, and that other applicants were going to be discussing that point. Which is a shame. And, I get it, and that's a reasonable answer to give, but I do wish that he had something to say on the matter, since it did feel like he had the ear of the judges at least a little bit by that point. Even though Meehan and the three judges had engaged in a fair amount of verbal jousting throughout much of his presentation. But there again, we saw for the umpteenth time in the first hour and a half, the judges attempted to assert that reasonable for hunting or sport can mean reasonable in the light of public safety concerns, which to me indicated rather clearly that the judges were stuck in a cognitive rut. It appeared that they were of the mind that, well, of course the government has the power to ban firearms for public safety reasons. Why shouldn't they be able to do that? And neither Meehan nor Miller did enough to break them of that train of thought. However, that train of thought didn't last forever. Next up, we saw Thomas Slade, Meehan's colleague, to discuss the failing of Injustice Kane to form an adverse inference in response to the government's declaration of cabinet confidence under Section 39 of the Canada Evidence Act. But I gotta be honest here, I didn't listen to it. After seeing how the first couple of presentations from Miller and Meehan went, and how little their points appeared to matter to the judges, honestly I was kind of demoralized and feeling defeated. I'll put Tracy Wilson's live tweets from the day on screen if you want to read more about the things that Slade was saying. Now I know that's kind of unfair to you viewers, and that's certainly unfair to Mr. Slade, since everyone else on the team is getting some sort of shout out in this video, but it is what it is. And that's actually kind of a bit of a shame too, because based on what happened on day 2, I think his words had some definite impact on how the hearing went. Honestly though, with how brutal I thought the justices were being with our first couple of applicants, even before lunch on the first day, I was rather certain that things were looking hopeless. I was starting to really buy into that pessimism that a lot of people have regarding the futility of any expected legal action to play out in favor of lawful firearms owners. And honestly, if it wasn't for having this channel, I probably would have turned it off at this point and never come back. But after Slade's presentation was the lunch break, which was an hour and a half long, and it gave me some time to collect my thoughts. And quite frankly, also to stop pouting and being so butthurt. So after lunch, I was back with everyone else to see this thing through. And I'm glad that I did, because after lunch, things went a bit better. Next up was Arkadi Bouchelev for the Doherty applicants. Bouchelev spoke primarily to the ultra vires of the OIC, much like Sarah Miller of the CCFR did. And his initial presentation was actually kind of interesting. Instead of reading Section 117.15 of the Criminal Code again for everyone in the courtroom, he came out with the assertion that Section 117.15 of the Criminal Code says that the Governor and Council may not prohibit any firearm which is reasonable for use in hunting or sporting purposes. Which isn't precisely what the statute says, but that is its intended meaning, and that is the point we've been arguing through 2 hearings now. However, I think the assertion is far more compelling than simply reading the statute and then trying to work up to this conclusion. Because when you start from this conclusion and work your way backwards to the statute, as Mr. Bouchelev did, its meaning becomes kind of self-evident. And this is where we finally resolve one of the nagging questions which had been chasing the applicants all morning. This was something that the judges repeatedly asked all throughout day 1 until this point, and something that Injustice Kane aired on in her ruling. Why shouldn't the Governor and Council be able to consider public safety when banning firearms? After all, Cabinet does sit at the apex of the executive in the Canadian government, so it has broad powers and is granted a wide latitude of consideration. And even Injustice Kane said as much during her ruling, and it was based on well-established existing precedent. It's also the reasoning that the government said they had acted upon. So, that's a very fair question for the judges to be asking. And Bouchelev was very specific in his response. The issue at hand for the court to decide upon wasn't that the governing council or even that cabinet itself couldn't have the authority to consider public safety. It was actually that the statute itself didn't allow them to consider generalized concerns over public safety to trump the reasonableness of a firearm in its use for hunting or sporting purposes. Such an interpretation would make any proposed restriction by the statute completely meaningless. He then further clarified it's not like the government couldn't go about banning hunting or sporting firearms, but rather that the statute prevents them from using the regulatory powers to do it. He explained that the government definitely does have the power to ban hunting and sporting firearms in the name of public safety if they want to. The only catch is that they have to ban such firearms through way of legislation, and not through regulation as they have done here. He was very specific. What they did isn't really the issue here. How they went about doing it is the issue here. And even though other lawyers, such as Miller, had made a point of already saying this, the way they were saying it was looking like it was falling on deaf ears. And this was something that the justices seemed stuck on for the first several lawyers and didn't really understand it until he made a point of repeating it multiple times. Like, Bouchelev really wasn't the first person to say it, but the way he said it appeared to make this point stick, because the justices didn't ask this question again after Bouchelev made it click. And one of the ways he did this was to say, suppose the government is right. Suppose the Governor in Council has the authority to ban firearms through an order in Council in the name of public safety. Suppose that reasonable for hunting and sporting purposes means reasonable in the name of public safety. Where does that end? Subsection 2 is clearly labeled as a restriction, so what restriction would that statute offer? Because the respondent has yet to offer a single example of a firearm which could not be banned under such a rationale. And Mr. Bouchelev was right to point this out for the judges because that's essentially the crux of this case. And this is also what Miller was saying when she said that if public safety was the only concern, then subsection 2 would not have been imposed. After all, if public safety is truly the only concern that matters, then how does that offer any kind of restriction on what they can or cannot ban? How is any firearm safe if the threshold is merely danger? After all firearms are inherently dangerous, and all parties agree to this. So if danger in public safety is the only threshold, how is any firearm safe from being banned through regulation? And Justice Mactavish took particular offense to this suggestion. She posited that surely this time is a good time to ban firearms based on public safety concerns because this time they're getting it right. Surely no one needs these military or tactical type firearms because these ones are not reasonable for hunting or sporting purposes because they're obviously more dangerous than other firearms. That somehow banning these military type firearms this time around is fine, and that in the future any remaining firearms won't be banned next time because the remaining firearms are implied somehow to be intrinsically more reasonable for hunting or sporting purposes in some unquantified way, which makes them incapable of being dangerous for public safety. Somehow. But she really missed the point of what Bouchelev and the other applicants were saying. That rationale doesn't actually make any sense because after all, if this time is a valid justification now, then this time is a valid justification always. The statute offers no flexibility. Either the statute allows firearms to be banned solely on the grounds of public safety, or it doesn't. The effectiveness or the intent of the regulation is not the question for the court to be answering. The question that they should be answering is if the Governor and Council's actions fall within a reasonable interpretation of the powers offered by the governing statute. If public safety is a valid and reasonable interpretation of the statute, then all firearms can be banned in the name of public safety because all firearms are inherently dangerous. And all of this brought Mactavish and Bouchelev to the critical word: opinion. They had been going back and forth for a good 5 to 10 minutes at this point, having something more like a debate rather than allowing Mr. Bouchelev to present with the occasional question here or there. And honestly, that's fine with me. Like, after all, the government is afforded deference, and the onus is on the applicants to prove that the respondents are the ones in the wrong, that the government and council is the one who acted unreasonably. And what this means is that the default presumption is that the government acted reasonably. And so, if it appears that the judge might be taking the side of the government in something approximating debate, that actually makes sense. The judges should actually be resistant to the suggestions of the applicants, and it is the job of the applicants to convince the judges to overcome the legally required preconception that the governor and council acted reasonably, and that Injustice Kane was correct to rule as she did. Like, those are not small hurdles to overcome. However, you're about to see why I think Justice Mactavish took it a step too far, and why I said at the beginning of this video that she may be too biased to rule independently of her personal beliefs. Back to the case now. Bouchelev is on the most critical and difficult part of the statute, the word opinion. The statute says that things cannot be banned if, in the opinion of the governor and council, such things are reasonable for use for hunting or sporting purposes. And so, one way to interpret the statute is that the opinion of the governor and council is the only thing that actually matters. However, is that interpretation reasonable? And in my view, I would say no, and I'll explain why in the next video in my series, but even if you do choose to interpret it that way, Bouchelev said that the opinion itself must also be reasonable for the statute to have any meaning. However, the judges wanted to know why it wasn't enough to merely hold the opinion. After all, that is what the statute says, and the res clearly stated that the governor and council had formed the opinion. Justice Mactavish even said that it was rather clear that the governor and council turned its mind towards the reasonableness for hunting or sporting purposes because the res itself said as much. And frankly, it does say that. However, Miller pointed out earlier that this was merely a repetition of the statutory language. Simply copying and pasting the statute into the res doesn't actually tell us anything about their opinion, and Vavillov's reasonableness precedent has this to say about it in paragraph 102. Quote, reasons that simply repeat statutory language, summarize arguments made, and then state a preemptory conclusion will rarely assist a reviewing court in understanding the rationale underlying a decision and are no substitute for the statements of facts, analysis, and inference, and judgment. End quote. The applicant suggests that the opinion itself also has to be reasonable for the statute to have any meaning, and I think they are entirely correct on that point. Bouchelev built on the base that Miller had formed earlier by further scrutinizing the opinion itself based on the very little information that we actually have available from the res. He asserted that there really isn't any information in the res which explains the formation of the opinion. However, the judges would always respond that the res provides plenty of explanation for this opinion, just like Injustice Kane did in her ruling. Justice Mactavish was also particularly insistent on this point. Like, for her, it was rather clear that the opinion was based on the fact that these firearms were inherently dangerous due to their tactical or military design, which makes them capable of killing large numbers of people in short amounts of time, and therefore are not suitable for civilian use. She cited many different lines from the res to this effect in her conversation with Bouchelev. And for what it's worth, the res does absolutely say these things, that's not up for debate. Like, it's not like she was trying to extrapolate some hidden meaning from its words or anything. However, Bouchelev rejected this notion. He responded to these concerns saying that these opinions are not specific to only certain types of firearms. All firearms are able to do these things. All firearms are inherently dangerous. All firearms are capable of harming people. All firearms are capable of having high-capacity magazines, but that such magazines have been banned in Canada for decades. Mactavish responded with concerns that these restrictions can be circumvented, but again, Bouchelev was insistent that this is not a problem unique only to some firearms. All firearms are capable of circumventing magazine capacity laws. And at this point, after several minutes of this back and forth, Mactavish kind of lost her cool for a moment. She just blurted out, she was like, no! Just a little bit of anger and outrage at the notion that maybe, just maybe, these firearms may not be the instruments of evil that the government and the media and the gun control activists claim that they are. Which should have absolutely no bearing on a judge in court. And she certainly shouldn't be shouting down a lawyer in court for simply bringing up his points. And you could also see that when she said that, Bouchelev kind of recoiled for a moment at this sort of weird outburst from a judge. He didn't really break his stride and he kept the debate going, but you could tell from his reaction and his sort of astonishment that this was something of a very unusual response. So, right there, for me at least, she's a write-off. I don't think she even can be convinced that the government did anything wrong. Both Justice Stratus as well as Chief Justice Montini were plenty critical of the applicants as well, but this outburst from Justice Mactavish goes well beyond even aggressive criticism in my opinion. It's one thing to disagree, but that's not what this was. This sort of outburst is a declaration that I don't want to hear what you have to say. That the completely reasonable point of view that Bouchelev was presenting was somehow unacceptable or intolerable in her eyes. And again, that sort of thing isn't as simple as mere disagreement. That sort of thing, to me at least, indicated an unwillingness to have her mind changed. So for that reason, I don't see how Justice Mactavish can rule in any other way except to side for the government. But who knows? She's had some time since the hearing to think about it and to reflect on what was said and what was presented, and maybe she can reconcile her beliefs with the evidence and presentations at hand. So who knows? But not all is lost. We still have 2 of the 3 justices left to convince, and we only need a majority to win the case. And even though all of the judges were pretty rough with him, the other 2 were mostly rough for good reason. Like, he was saying some pretty potent things, and they had every business of getting to the bottom of it. So with the rest of his time, Bouchelev touched on a bunch of other topics. He questioned the lack of a definition of the term assault-style firearm. He questioned the lack of a definition of the word variant. He questioned the legality of the firearms reference table and the authority of the Specialized Firearms Support Service. He questioned the confidentiality of the supposed evidence used to inform the government's opinion. And so, I really felt like he focused on most of the important things, and you can learn more about these topics from earlier videos in the series. And the last of the applicants before the interveners was Christine Generoux. Christine is a bit different from the other applicants because, just like me, she's also not a lawyer. And it showed, but not at all in a bad way. It was actually kind of interesting to watch. Like, the lawyers all throughout the day really focused on a lot of the technical, factual, and legal aspects of the case, which is probably what you would expect out of a lot of lawyers. But Vavilev's reasonableness precedent also allows you to directly question the internal rationality of a decision if the given reasons exhibit clear logical fallacies. And Generoux really leaned into that aspect of the reasonability argument a lot more than the lawyers did, I think. And to great effect. So far as I'm concerned, her presentation was probably the turning point in the hearing. And she gets my unofficial Team MVP award. Like, as much as I loved hearing Eugene Meehan speak earlier in the day, I think Generoux probably made the most impactful statements out of any of the applicants. But credit where it's due, I also think that happened because the previous 4 lawyers really softened up the judges and made their minds a bit more pliable as the day went on. Generoux probably would not have been as successful as she was if she had to present much earlier in the day. And Generoux came out of the gate absolutely swinging for the fences. She started out with a few basic definitions and reiterations of relevant statutes, but then she almost immediately got into discussions from the Hansard debates. And for those who don't know, the Hansard debates are essentially a publicly available record of what was discussed in Parliament from various MPs regarding various regulations and legislations. And Generoux used this record to go back in time to the formation of the Firearms Act and the discussions regarding it in order to prove a number of things, but most importantly, to prove the legislative intent behind the restriction laid out in Section 117.15, subsection 2 of the Criminal Code. And legislative intent is effectively the crux of what this reasonableness review is all about. As a reminder, Vavilev's reasonableness precedent has this to say. Reasonableness review does not give administrative decision makers free rein in interpreting their enabling statutes, and therefore does not give them license to enlarge their powers beyond what the legislature intended. And it goes on to say that a court interpreting a statutory provision does so by applying the modern principle of statutory interpretation. And that is, the words of a statute must be read in their entire context and in their grammatical and ordinary sense harmoniously with the scheme of the Act, the object of the Act, as well as the intention of Parliament. So basically what this all means is that the government is required to act in accordance with what was intended by the statute, and therefore, parliamentary intent is essentially the cornerstone of reasonableness review so far as the court should be concerned. And Generoux started off on a high point with this by looking at what Parliament had to say regarding various aspects of the Firearms Act. And in particular, she focused on what Justice Minister Alan Rock had to say about it. For those who don't know, Justice Minister Alan Rock was the one responsible for then Bill C-68, which resulted in the creation of the Firearms Act and the related amendments to the Criminal Code. He was the sponsor of the bill at the time, so any discussion of legislative intent really stops with him, since he was the one responsible for bringing forth this legislation. Now, Generoux did have a lot to say and a lot of evidence to show regarding this, but 2 quotes in particular stood out to me. Now, unfortunately, I did not record these quotes in real time because she said them so quickly and I then had to look them up after the fact, but I will be putting these quotes on screen if you want to read along to them. Some of these things will be the things that Generoux pointed out specifically, and others will be things that I found along the way while looking for her quotes. So first off, Justice Minister Alan Rock said in multiple debates regarding C-68 that the purpose of the bill was to punish criminals and the criminal misuse of firearms while simultaneously protecting lawful firearm ownership which poses no threat to public safety. And Generoux quoted Minister Rock on this specifically. Firstly, strict measures to counter the criminal use of firearms. Secondly, specific penalties to punish those engaged in the smuggling of firearms. And thirdly, broad measures to define what constitutes the lawful use of firearms in a manner that poses no threat to public safety. And he also said, quote, "We have taken strong measures to deter the smuggling and illegal movement of firearms, and all of this while respecting the legitimate interests of law-abiding firearms owners who use their guns for hunting, sport shooting, or collecting." She then stated very firmly and very assertively that Section 117.15 subsection 2 of the Criminal Code clearly exists to honor that intended aspect of Bill C-68, which obviously it does. Like, it's there to protect our culture surrounding our hunting and sport shooting firearms. And this is the core of what everyone else was arguing in regards to the ultra-vires nature of the OIC. And this quote from the guy who proposed the law itself demonstrates the legislative intent behind our claims. Generoux then had another quote which unfortunately I was unable to find. And this is actually one of the reasons it took me so long to make this video. I spent quite a few evenings looking for it with no success. And this is especially unfortunate because it is something of a slam dunk for the case. I don't know if maybe it wasn't part of the Hansard debates, or maybe it was part of the Senate discussions, or maybe I was searching the wrong keywords or whatever else. But essentially, during the entire C-68 process, there was a lot of outrage specifically with the 117.15 statute from various opposition because they were concerned that it would allow the Liberals or some future government to reclassify firearms and mass ban them on a whim. Which, wouldn't you know it, happened almost immediately after the next time the Liberals got back into power. However, Justice Minister Alan Rock responded to this criticism by saying that such a thing would not be possible, that no interpretation of the statute could be used to mass ban firearms because all of the assault-type military weapons had already been banned, and all that was left was ordinary firearms like rifles, shotguns, semi-automatics, and 22s. Now, like I say, I couldn't find that exact quote, but I did find something rather similar during the third reading of Bill C-68 just before it was sent off to the Senate. And Justice Minister Alan Rock had this to say, likely while reading from a script as he presented on third reading, regarding the potential of confiscation. As to confiscation, those who oppose registration allege that it is the first step to confiscation. To them, I respond that in 1940, the government of this country introduced mandatory registration of rifles and shotguns as a part of the war effort. There was compliance and no confiscation. To those persons, I say that in 1977, when the present system of firearms acquisition certificates were introduced, the voices again were raised that confiscation would be the inevitable result, but there was no confiscation. This is the position of people who have run out of real arguments against gun control. They are trafficking in fictions. So, straight out of the mouth of the guy who put the statute pen to paper, he declared the intent of the legislation, and he was very clear that it was not to be used to do the things that the Liberal government is now using it for. C-68 was not to result in mass confiscations. Justice Minister Alan Rock even went so far as to call that concern a fiction. Not something which shouldn't happen, not something which wouldn't happen, but rather it was something which couldn't happen. It was a concept so absurd as to be considered fictitious by him. Quotes like these, and the ones put forth by Generoux, speak directly to legislative intent, which is the cornerstone of the reasonableness standard. Vavilov has this to say: "The administrative decision-maker's task is to interpret the contested provision in a manner which is consistent with the text, context, and purpose, applying its particular insight into the statutory scheme at issue. It cannot adopt an interpretation it knows to be inferior, albeit plausible, merely because the interpretation in question appears to be available and is expedient. The decision-maker's responsibility is to discern meaning and legislative intent, not to reverse engineer a desired outcome. If, however, it is clear that the administrative decision-maker may well, had it considered a key element of the statutory provision's text, context, or purpose, arrived at a different result, its failure to consider that element would be indefensible and unreasonable in the circumstances." So what this all means is that if the court takes these quotes presented by Christine Generoux from Alan Rock to heart, that's the nail in the coffin for the case right there. Like, it's GG, it's over. It clearly demonstrates that the legislature did not intend for the OIC powers to be used in this manner. In fact, it shows rather clearly that they had deliberately set up safeguards to prevent it from being used in this way, namely, the restriction that was set out in subsection 2. And for what it's worth, I think our 3 judges really did take this to heart, because for the first time all day after Generoux brought this up, The judges were silent. They did not interrupt her, they did not scold her, they did not berate her with a barrage of questions. They just sat there and listened and learned. Generoux continued with some of the information from the Hansard debates, shoring up the reasonable interpretation of 117.15 of the Criminal Code. But then, she went on a warpath. Like, she absolutely picked the government's OIC and RIAs apart. Vagueness says that the reasonableness review isn't concerned with a line-by-line treasure hunt for error, but Generoux found errors in nearly every single line of the damn thing. And it was pretty cool to see in a lot of ways, because just like me, she's also not a lawyer. And she ended up saying a lot of the same things I did earlier in the series. Now, of course, I'm not taking credit for her words or anything. She probably doesn't even know who I am. But even if she does, she has been in this fight for far longer than I have. But in particular, she really ripped apart the government's main 3 criteria for banning these so-called assault-style firearms. Namely, that they are capable of sustained rapid fire, that they are of modern design, and that they are present in large volumes in the Canadian market. And I also picked this nonsense apart as a dedicated episode in part 4 of this series. And she said much of the same things. Commonly used firearms are not more dangerous simply because they are common, and not only that, commonly used to be the threshold of something to protect. That used to be the limit on the OIC powers before the statute was changed by Bill C-68. But there are still plenty of areas in other places of the law where it says commonly used is still the threshold. She also said modern firearms are more safe, not less safe, which is true. And this makes them inherently reasonable, not unreasonable. And she also laughed at the idea that our 5-round magazines are somehow capable of sustained fire, whatever sustained fire actually means. Now, she didn't really get into rapid fire, which was sort of unfortunate. And Generoux, if you're watching this, please go check out part 4 in this series, because there are some legitimately good arguments for you to use on that front if for some reason you end up having to go through all this nonsense again in front of the Supreme Court. But with how well she did with her presentation, and especially with how poorly the government's lawyers did on day 2, I doubt that she's going to need to. She spoke on a whole bunch of other topics and touched on the issue of vagueness and the issues of subdelegation of authority for the Firearms Reference Table and just everything else. And she cited paragraphs of precedent from the Firearms Reference Act legal case, which we also talked about during my video on the handgun freeze possibly being unconstitutional. And I think she made a bigger point of discrediting the government's case, in particular, the government's witnesses, more than any other applicant did. She was also particularly pointed at the ridiculous notion of the Firearms Reference Table not being legally binding, yet somehow we could be charged with a crime on nothing other than the Firearm Reference Table say so. And this is something that the other applicants mentioned as well, and something that Justice Stratus picked up on for day 2. So altogether, I think she was something of a superstar out there. Like, it's really hard to explain everything she said in a condensed second-hand fashion. It was one of those, you really had to be there kind of moments. However, one thing I do wish she spent a little bit more time on was the Section 15 charter violation. Section 15 is supposed to protect us from discrimination, and I think a lot of the modern gun control violates this right that we're supposed to have. Christine Generoux was the applicant who brought forth these arguments, but she didn't really spend a ton of time on it with the hour that she had, which is also probably why she didn't speak to it much. She did, and she brought it up, but more than anything, it really felt like she wove it into the language of her other arguments, rather than making a stand on that point. But to be fair, that was probably also a matter of strategy as much as anything else. She only had an hour, and she made excellent use of that hour. So I'm not really sure what I would like to see her drop from her other arguments to make this point. And even if she had, it's likely it would have fallen on deaf ears on appeal for the same reason it failed with Injustice Kane. I think the existing precedent precludes those arguments from working. But if she gets to the Supreme Court with it, I hope she redoubles her efforts on that front, because the Supreme Court isn't bound by precedent the same way that lower courts are, and they can even set new precedent to override old ones if they can be convinced to do so. And I think that Section 15 is one of the ways we'd be able to get some kind of permanent buffer to keep liberal governments from destroying our community. Because even winning elections is only a temporary reprieve. But I don't want to be too critical of Generoux. She absolutely killed it out there. 10 out of 10 as far as I'm concerned. Very well done. Her and Meehan were the stars of her applicants as far as I'm concerned. Now next up, we have our 2 interveners from Alberta and Saskatchewan. They each only had about 15 minutes for their submissions, so the next 2 will go by pretty quickly. First up was Alberta, and I don't know if it's just me, or maybe she just had the bad luck of following up after the powerhouse that was Christine Generoux, but it was a pretty stark contrast from that. It felt like Alberta's lawyer was the most lackluster lawyer of both days combined. She was very quiet, very meek, very mild, and watching her kind of felt like watching a girl from high school in front of the class do a book report. at least in my opinion. And I know that sounds kind of harsh, especially when she's there trying to help us out in our community, but I'll be honest, I watched the whole thing start to finish, and I didn't write a single thing down. Not a single thing. Nothing she said was noteworthy to me in a very literal sense. And I do remember she spoke on the ultra vires issue, and she told the judge that public safety alone is insufficient grounds to use the OIC powers to ban firearms, but most of the other applicants had already said such things. I didn't really feel like she added any unique arguments or unique perspectives to the debate. And her demeanor didn't do her any additional favors in driving that point home for us. But to be fair to her, 15 minutes is not a lot of time. Most of the videos on this channel aren't even 15 minutes long. So it might be that if she had more time, she could have provided a more in-depth, detailed analysis of what she was explaining, and maybe that could have made the difference. Who knows? Now, Saskatchewan's lawyer, on the other hand, was something of an interesting spectacle, to say the least. He was an absolute pleasure to watch, but the legal foundation for his argument was basically non-existent. So he spoke primarily to the Bill of Rights and to how this confiscation of our property is a violation of those property rights in the Bill of Rights. So if you want to know more about this argument, please check out the last few minutes in part 1 of the series. His arguments really didn't evolve the case much beyond what was already said to Injustice Kane. But for the first couple of minutes in his presentation, he and the judges, Justice Stratus and Montini in particular, went back and forth on precedents and discussions on the narrowly applied precedents of the property rights in the Bill of Rights. And those precedents basically say that you're only allowed that protection during criminal proceedings, and that the OIC itself hasn't actually charged anyone with a crime as of yet. He said that the Bill of Rights is meant to be a quasi-constitutional document, and that the Bill of Rights also explicitly says that no other law of Canada is to interfere with these rights. And so, if it only applies during criminal proceedings, that is too narrow of an interpretation for the Bill of Rights to fulfill its intended role. Just as in Injustice Kane's ruling, however, the judges said that they are bounded by precedent, and the precedent is very clear, even if they don't agree with it. And the right to enjoyment of property did not actually receive true constitutional status by being carried over to the Charter, like most of the other parts of the Bill of Rights did. And so, our clumsily bashful yet charming hero carried on and essentially tried to bluff his way through his presentation. He had a lot to say, and they were all good and fair arguments, but none of it trumped existing precedent. And after a while, the judges kind of picked up on this, and they kind of ended up laughing with each other as he tried to charm his way through his presentation. So he was something of an old blood lawyer, and he was often caught himself referring to the justices by older titles such as Lord, which isn't really used anymore over Your Honor. And I felt like that was a good note to end the day on after an otherwise rough day. Even though he didn't have a snowball's chance in hell at winning his argument, I was smiling through the whole thing. Kind of really felt like one of those video game moments where you put all of your points into charisma and just try to bluff your way and persuade your way through the entire game. That being said, if he puts that argument in front of the Supreme Court, I think he might actually win it. I think he's completely right that the Bill of Rights doesn't fulfill its purpose if its effect is so narrowly applied only to criminal proceedings. And the Supreme Court has the authority to fix a bad precedent. That being said, the Bill of Rights is also a bit outdated and is usually irrelevant in light of the Charter, but an old law is no less applicable than a current one. So I'd actually kind of be curious to see how that would play out. But before he finished up, he dropped an absolute bombshell on the court. Most of our applicants spent very little time actually criticizing Kane's ruling, which is essentially the purpose of an appeal in the first place, and instead spent most of their time just reiterating the arguments they made to Injustice Kane. Which is fine. I think most of their arguments should have won the first time around anyway. And Injustice Kane had no business ruling against them on a number of those points. However, I think our friendly neighborhood lawyer here picked up on that because he had one more thing to say. In paragraph 320, Injustice Kane sought to discredit the claims that there was some kind of bargain or balance struck between balancing public safety and legitimate firearms use, which, there are literally publicly available records of politicians explicitly stating that this was the intention of then Bill C-68, so that's just Injustice Kane ignoring evidence because it was inconvenient. So nothing new to see there, I guess. But then she went on to say that even if this was true, that happened over 25 years ago. The landscape has evolved and Parliament is not bound by previous parliaments, and that Parliament responds to current issues. But our intervener pointed out something very important here, which serves as a reminder to what I've been telling you all along. The cornerstone of reasonableness review is parliamentary intent. That intent doesn't change over time. That parliamentary intent is fixed the moment the statute is signed into law, which is a glaringly bad mistake for her to make when considering the reasonableness standard. He then pulled the pin on that grenade and walked away, leaving the court to dwell on the aftermath.
Cool guys don't look at explosions.
Now, despite how the day ended on a fairly positive note, at this point I was still of the mind that it was fairly hopeless. Regarding most of the criticisms for the judges, particularly the idea that subsection 2 could mean public safety, and that the vagueness of the word variant is fine, I really felt like we didn't do enough to break them of that nonsense. And not only that, but I felt like in some sense, it wasn't even possible to break them of that nonsense based on the way they were asking their questions. It's a bit hard to describe, but it is a sentiment that a lot of us who were watching it live were sharing. And the big reason I keep making a point of telling you all about my personal feelings and thoughts towards the case is I want you to really understand later on that when I tell you I think we're going to win, I mean that honestly. Like, there was plenty to get down and depressed about in this case, and for a lot of the first day I really felt like we were just going to be railroaded into another Injustice Kane type ruling, and who knows, maybe we still will be. But when you see how badly the government did on a few key points on day 2, that idea becomes a lot less realistic. However, if the Federal Court of Appeal still fails to rule in our favor after all of the information presented to them over these 2 days, that'll probably be my canary in the coal mine moment. Like, I don't think there ever will be justice for us in Canada. So far as I'm concerned, I don't see how the justices could even rationally explain such a thing if they decided to shoot down our appeal. I want to be clear, I don't think we could win on every point, but we should win on some of the bigger ones. So, on to day 2. Most of day 2 belonged to the government's lawyers, but in the last hour or so of the day, the applicants were given like 10 to 15 minutes each to respond to the government's case in a process known as the rebuttal. As far as day 2 went, the respondents, much like our applicants, didn't really evolve or advance their arguments much. I mean, maybe it'd even be fair to say they didn't do that at all. But why would they? They won the last time around with Injustice Kane by using those arguments. May as well double down on it. They very much took a if it ain't broke, don't fix it kind of approach to their arguments on day 2. Being that their presentations and arguments were so similar, and seeing that this video is already ridiculously long, I'm going to gloss over much of that. So if you want to learn more about the broad strokes of the government's arguments from the government's lawyers, please check out part 1 in this series. So I'm only going to be focusing on the couple of areas where the respondents made some really outrageous statements, and then 2 places where I think the government lost this case big. One of the big things I think our justices did well, particularly Justice Stratus and Chief Justice Montini, is that they took the meaning and the wording of the statute to heart. In the Ries, and as well as in the legal presentations from the government's lawyers, they frequently implied and even outright stated that these gun bans were fine because there's still so many alternatives available for hunting and sport shooting. But such observations are actually entirely irrelevant. A firearm is not more or less reasonable for hunting or sport shooting based on the idea that there are alternatives. Necessity is not the test. Necessity isn't even a relevant consideration. And our judges were extremely keen on this point. Anytime the government lawyers attempted to suggest, imply, or even insinuate anything to that effect, our justices shot that idea down rather quickly. Which was good to see. Because despite the fact that even though Justice Kane also admitted that necessity was not the test in her ruling, she was completely happy to accept the idea that these gun bans were somehow less inappropriate or more reasonable because of the availability of alternative firearms. But if necessity is not the test, then whether or not there are alternative firearms available becomes entirely irrelevant information. I think our lawyers did a pretty good job of driving this point down for the court because they appear to have completely accepted that idea by day 2. However, there were other areas of concern where all 3 justices were surprisingly silent on important issues. And one of these areas was regarding the definition of the term assault-style firearm. Being that it is essentially the focal point of the order in council and the justification for the Ries, it's a rather important term. However, on day 2, the government's lawyers did a number of things where they attempted to play that term down. And one of the things they stated was that our side, the side of gun owners and the applicants, that we are somehow the ones who are attempting to conflate that idea that assault-style firearms are assault weapons, and that the respondent, and therefore the government, isn't the one making such claims, and they have never been the ones making these claims. From the respondent's point of view, assault-style is just a term. It's just a blanket term, doesn't mean anything. It's just the arbitrary term that they use to categorize firearms of a certain type, and it shouldn't be scrutinized any more than that. I mean, the word ridiculous doesn't even begin to approach the kind of nonsense that such an argument embraces when you consider it in relation to the facts at hand here. And I plan to break that nonsense apart in my next video, but the more concerning part here is that the justices didn't appear to even bat an eye at that assertion. Now, for the most part, all throughout the day, the judges actually did a decent enough job cracking down on the myriad of outlandish claims being levied by the respondents. Not that they were outright disagreeing with everything that was being said, of course, but most of the time when the respondent said something that was intriguing or provocative, the judges were sure to at least ask them questions about it to better understand where the respondent was coming from. But for some reason, they didn't do that here, which means they might actually have some sympathy for that idea. And I think part of that reason may have been due to our side not being as convincing regarding the problems with the assault-style terminology. And this was also an issue that the applicants failed to address in rebuttal, which I thought was something of a missed opportunity to say the least. But like I say, I'm going to pick this nonsense apart myself in the next video in this series. So overall, I think the second day went very well, and I think the respondents failed on 4 key arguments. They struggled with the arguments regarding the subdelegation of authority to the Specialized Firearms Support Service and the Firearms Reference Table. They struggled with the adverse inference issue resulting from the assertion of cabinet confidence. It wasn't entirely obvious, but I think they won the case for us surrounding Section 7's vagueness concerns and the undefined use of the word variant. And then lastly, I think it's completely fair to say that the government's case utterly imploded regarding the ultra vires use of the OIC powers. So, for the first hour and a half of the day or so, things were fairly uneventful in the courtroom as the government's lawyers presented their case. But then things picked up rather quickly as we got into the questions regarding the unlawful subdelegation of authority. There was a lot of back and forth from the judges and the respondents on this topic, but ultimately the question comes down to whether or not the Firearms Reference Table is legally binding, or if it is an administrative document which merely reflects the opinion of the Specialized Firearms Support Service. And Justice Stratus in particular took issue with the idea that the FRT is somehow not legally binding. When this topic came up, Justice Stratus remembered the applicants talking about a business which had been effectively shut down due to the arbitrary change of classification on the Firearms Reference Table. And this was Mactavish Defense, if I recall correctly. They were making a single unique firearm known as the SLR for deliberate non-restricted hunting and sporting use in Canada. It was not banned by name in the 2020 OIC, only later on by the Specialized Firearms Support Service by declaring it as a variant on the Firearms Reference Table. And Justice Stratus rightly took issue with that. He acknowledged that there was no right to firearms or firearm ownership in Canada, but that the creation of a business and the earning of a livelihood, as well as the expectation to not have that business reasonably interfered with, was something of a right in Canada which had to be respected. So for clarification, Justice Stratus asked the government's lawyer what would actually happen if they continued to produce and attempted to sell the SLR firearm despite its listing on the Firearms Reference Table as a prohibited firearm. The respondent informed him that of course such an action would lead to arrest and criminal charges being laid, but that such things are okay because he'll still get his day in court and a chance to debate whether or not the firearm in question is actually a variant to begin with. But Justice Stratus was not having any of that. He observed that the change of classification which could kill a business and cause someone to face criminal charges could hardly be considered something which was just merely an opinion or an administrative tool, and that trying to justify it by claiming that it isn't technically legally binding is hardly any excuse. He even chuckled a little bit at this ludicrous notion as he was explaining this to the respondent. While the other 2 judges were fairly silent on this topic, I think it's fair to say that we succeeded in getting at least Justice Stratus on our side for the issue regarding an unlawful subdelegation of authority. And I don't know if someone pissed in his Cheerios that morning or something, or maybe he just woke up on the wrong side of the bed, but Justice Stratus also wasn't having it with the government's refusal to disclose information upon which they based their OIC. And he even overtly disagreed with Injustice Kane over some points regarding it. Like, Injustice Kane, for example, was all too happy to agree with the government on the ridiculous notion that selective disclosure of information was somehow worse than refusing to disclose any information at all. Justice Stratus, more or less, stated that this was nonsense, and he even specifically pointed to Vavilov's reasonableness precedent to do it. He kept mentioning that judicial review was to remain robust, but how can it be robust if we don't know how the decision and the reasoning came to be? He didn't say it specifically, but that's much of what Vavilov is actually all about. One of the hallmarks of reasonableness is transparency, and he went back and forth with the respondent for several minutes on this in a number of different ways, but essentially what that entailed was that Justice Stratus understood that the Rias explained the thought process and the rationale behind the ban, but not what that thought process or the rationale was based upon. The foundation for all of the things that the OIC and the Rias claimed it wanted to do, ultimately, remain shrouded in secret, and the evidence to shore up that foundation, as well as the evidence which would contradict that foundation, isn't able to be criticized. So how can judicial review remain robust if the government's argument is essentially, just trust us, bro? Now, of course, the respondent again claimed that they were under no obligation to disclose any of this information, and that cabinet confidence is entirely their prerogative, and that they have no duty to explain themselves beyond the information which is already within the RIAS. But as you're about to see shortly, even the government doesn't believe their own nonsense on that. So, score another point for Justice Stratus. I think it's quite likely that he will rule for an adverse inference on this issue. There was a bit more engagement on this topic from the other two justices, but not enough to say for me one way or the other where they might go on that. I do want to say it's not exactly like Justice Stratus is on our side here either. Like, there were plenty of times he was unduly silent or when he showed a fair amount of agreement with what the respondent would claim. Like, he's certainly not going to rule for us on every point here. But on 2 or 3 of the bigger ones, I think we actually have a decent chance for favorable results here, as they appear to have had some sway with him. And the biggest of those points, the question as to whether or not Cabinet exceeded the statutory limits of its authority, the ultra-vires issue, wasn't actually Justice Stratus's handiwork. That came from none other than Chief Justice Montagny himself. So when the government's lawyers saw that he was losing ground with Justice Stratus on several issues, he busted out Old Reliable, the one tried and true slogan which has gotten the Liberals through every scandal and every gun control push since time immemorial. Public safety. On day one, our lawyers were frequently confronted with the question of why can't reasonable for hunting and sporting purposes mean reasonable in a public safety context? And this question was primarily asked by Justice Stratus and Chief Justice Montagny. Our side's response was always that the statute doesn't allow for it. Public safety concerns are addressed by subsection 1. Protecting hunting and sporting, even in the light of public safety concerns, is the domain of subsection 2. And I really felt like this point had fallen on deaf ears on the judges on day one, mostly due to how he presented it. But if anything, this is a testament to the intelligence of the judges. Within a couple minutes of the respondents presenting on the public safety angle, Chief Justice Montagny interrupted him and asked, "So, what does subsection 2 actually do then? Like, everything you're saying here could be said solely of subsection 1. And I'm not gonna lie, I kinda lost my composure a little bit when I heard him ask this. Like, I grew up watching sports on TV like most guys, but unlike most guys, I'm a pretty passive spectator. I'm not that guy who gets up and yells at the TV and gets all excited and emotional when some big play happens. Never really seen the point. But I gotta tell you, when I heard the Chief Justice ask this question, I was on my feet, I was pacing the room, I was screaming at my TV. So yeah, if anyone has any doubts, I guess that makes me a nerd, doesn't it? But this question is the slam dunk I outlined in part 5 of the series. Like, we needed the court to understand only this point for the entire OIC to potentially be reversed. But better than the Chief Justice simply asking this question was the way the government lawyer responded to it. Like, initially he tried to play dumb, like he didn't understand the question or something, and he said that subsection 2 allowed the Governor General to consider public safety because of Cabinet's power of consideration is quite broad, and that public safety is the nature of all gun control laws. But the Chief Justice would not be deterred. He acknowledged that Cabinet has broad powers and authority, but that wasn't the issue. What he wanted to know was what effect does subsection 2 actually have if it's also appropriate to consider public safety as making some firearms unreasonable for use. And the fact of the matter is, the government's lawyer had no answer. He stumbled and mumbled and had plenty of ums and ahs to go around. And then he pulled a page right out of the book of Mendocino and attempted to dodge the question. He told the Chief Justice that he was going to get to that question, but first, he had some other important nonsense that he wanted to say. And that something else to say was, of course, a weak attempt at fear-mongering. The government lawyer changed the topic to the issue of vagueness and that the word variant should remain undefined. He started with the claim that they know that the word is vague, but that the vagueness is intentional in order to close various loopholes which could arise if they attempted to define it. He said he was concerned that if the government did make any definition for that word, that the industry would simply make something similar to a banned firearm which complies with that new definition, thereby skirting the intention of the law, which is a grave concern to public safety. And as the RIA states, all of these firearms are inherently dangerous to Canadians and they need to be banned to keep Canadians safe. But like a dog to a bone, Chief Justice Montagny would not be dissuaded. After several more minutes of this, he stopped him again, and again acknowledged that he understands the government's public safety perspective and concerns, but he was very specific this time that this was not his question. His question, very specifically, was that if in fact subsection 2 could be interpreted to mean unreasonable for public safety reasons, then what restriction would that offer on the ability to ban firearms under subsection 1? He tried to say that the changing in wording when the Firearms Act was signed into law was demonstrative of this. He said that the wording changed from commonly used to reasonable for use, and that signaled a greater leeway in interpreting the statute, thereby allowing the governor and council to opine that a firearm is unreasonable for hunting or sporting purposes, even if it actually is still in common use. And the government's lawyer also pointed out that we don't need to get bogged down on a single word. The statute also says that this is all in the opinion of the governor and council. So all that is required is that the governor and council simply forms this opinion. He then went on to read more garbage from the Rias about how the governor and council has clearly formed the opinion that these assault-style firearms are necessary and a threat to public safety, and so on. But yet again, the moment those words left his mouth, the Chief Justice stopped him immediately. Necessity is not the test, and if public safety is the test, then what restriction does that offer on subsection 1? And at this point, even Justice Stratus jumped in and attempted to clarify. They'd been going back and forth on this for like a good, 20, 25 minutes at this point, and the government's lawyer was still failing to answer this question. So Justice Stratus reiterated what the Chief Justice was asking in order to ensure that there was no uncertainty or ambiguity in the question itself, which, of course, there wasn't. And at this point, the face of our government lawyer here was starting to get a bit pale. He realized he was absolutely cornered, and there was no way out of it. The winds had left his sail, and he began panicking a little bit. He might have even been literally sweating, but it was kind of tough to make out on the low-resolution stream from the court. Now, conveniently enough for the government's lawyer, this had gone on for so long that it was time for another of these scheduled breaks throughout the day. Now, when I say scheduled, I want to be clear that it's actually a pretty informal schedule, and it was quite common for these breaks to be pushed up or back a few minutes in order to better fit the structure of the arguments for both the applicants and the respondents. So being that one of these breaks had come up, and being that the government's lawyer very evidently had no answer for this question, the court decided to take their break now to give him time to come up with an answer for that question. Now, on one hand, that kind of felt a little bit like favoritism, because no other lawyer in the hearing continued presentations between these intermissions. But on the other hand, I think this actually demonstrates just how important the court understood this question to be. Like, for example, the other side of this argument was made rather clear on day 1, and the judges were hammering us pretty hard with the question of why shouldn't public safety be a reasonable interpretation of subsection 2. And at the end of the day, they can only believe one of those two questions, despite the fact that they were rather aggressive with both parties on both sides of that question. So them giving the government lawyer a 50-minute break to come back with an answer, at least to me, demonstrated how vitally important it was to get an answer to that central question. Plus, if this happened to our side, I wouldn't want somebody losing the case for us, even when they actually may have a good argument, just because they got a little rattled over something. Now, I was a little concerned that during the break the judges may forget about it, or that the government's lawyer may use this break as an opportunity to weasel his way out of the question again, but that didn't happen. The moment the court resumed, Chief Justice Montagny demanded an answer to this ultra vires question, and the respondent finally had an answer. But his answer was shockingly bad, to say the least. And this faulty answer is the reason I believe we're actually going to win this court's case, just hands down. But before I get to that, I do want to point something out here. The respondent needed time to create this answer, meaning that this was not a question he thought he would have to answer. And I didn't actually watch Injustice Kane's hearing at the federal court, so all I really know about it is what was in her ruling as well as some of the evidence and affidavits which went into it. But if the respondent had to find or create an answer to the question of what restriction subsection 2 offers to the OIC power, that means very evidently that Injustice Kane did not ask him that question when her hearing was ongoing. Because if he had heard an answer to the question before, he'd still have that answer for it now. So either our side didn't raise the question, or Injustice Kane simply ignored that we did and didn't force the respondent to answer this very essential question like Chief Justice Montagny did. And we know this didn't happen because the answer the respondent came back with was exceptionally poor. So, after nearly 30 minutes of debate and a 15-minute break on top of that to collect his thoughts, what the government lawyer answered was this. Public safety is a reasonable interpretation of the restriction in subsection 2 because that is not the purpose of subsection 2. And he said the purpose of subsection 2 is actually to require the governor and council to justify their decision. It restricts the governor and council in that it requires an explanation as to why public safety is more important than the ownership or use of certain hunting and sporting firearms. But that answer is awful for 3 reasons. First off, justification isn't actually a restriction, so therefore it fails to answer the question. Simply having a requirement to explain yourself to others offers no true limitation on the scope of one's powers. But not only that, justification is also a natural and inherent requirement of reasonableness review. So writing a statute which requires justification is frankly completely unnecessary. Justification is one of the 3 intrinsic parts of reasonableness in Canadian law, according to the Vagueness precedent. And paragraph 86 has this to say: attention to the decision-maker's reasons is part of how the courts demonstrate respect for the decision-making process. This court explicitly stated that the court conducting a reasonableness review is concerned with the qualities that make a decision reasonable, referring to both the process of articulating the reasons and to outcomes. Reasonableness is concerned mostly with the existence of justification, transparency, and intelligibility within the decision-making process, as well as with whether the decision falls within a range of possible acceptable outcomes which are defensible in respects of the facts and law. Now there's more to that, but we'll come back to Vagueness in a moment, because the respondent's justification interpretation is bad for a second reason. The respondents allege that, despite what our side says, the res attached to the order in council was enough justification for their actions. But the res is a completely normal procedure found attached to most order in councils, and therefore, this answer would imply that they would need some other kind of enhanced justification beyond the normal measures, which is to say that the res alone shouldn't actually be enough. Vagueness continues with this: in short, it is not enough for the outcome of a decision to be justifiable. Where reasons for a decision are required, the decision must also be justified, by way of those reasons, by the decision maker to whom the decision applies. But even within the res itself, all they really say is that these so-called assault-style firearms are inherently dangerous because they have been used to hurt people, and the governor and council is of the opinion that they should be banned. Which brings us to our third reason for why the government's interpretation of their powers is so flawed. Like, the entire premise of them using cabinet confidence to hide information was on the grounds that they have no obligation to justify the evidence, only their actions. But Vagueness says that's not how it works. While some outcomes may be so at odds with the legal and factual context that they could never be supported by intelligible and rational reasoning, an otherwise reasonable outcome also cannot stand if it was reached on an improper basis. So Vagueness tells us that where reasons are required, those reasons need to line up with the relevant factual context in which those reasons were derived. And this completely contradicts what the government has been telling us for Injustice Kane's initial judicial review, as well as during the appeal now. The entire defense for most of the government's case is that they have no requirement to explain things to us. They don't need to disclose evidence, procedural fairness doesn't apply to them, and the only thing that matters is the governor and council forms the opinion that a firearm is unreasonable. That the opinion itself needs no context or explanation, it simply needs to be formed. And up until now, that has been the core part of their defense for years. But Vagueness says that if he's required to give reasons, then that simply doesn't cut it. So, in attempting to prove that subsection 2 can mean public safety because what it actually just means is justification, our government lawyer inadvertently torpedoed the rest of his case. But I think all of this is kind of moot, because justification isn't actually a restriction. Like, I really don't see how the courts could buy into that. But now, the court has 2 possible interpretations of the order and council powers found in section 117.15 of the Criminal Code. If they agree with the applicants, which they should, that subsection 2 is meant to protect lawful hunting and sport shooting, that view just makes more sense when you read it in the context of subsection 1. However, even if the court wants to disagree with us and side with the government, that the restriction is merely a requirement for justification, then following that through to its logical conclusion also completely breaks the government's case. So what this means is that both of those avenues are a win for us. And this is why I believe very strongly that the court will hand down a favorable ruling this time around. And deciding whether this order in council was ultra vires is the most important part of all of the issues presented in this review, at least as far as I'm concerned. If we win on this point, the entire thing can be quashed by the court. The specifics of how that could play out are actually still up to the court. So for example, they may order that the government fixes the OIC and reforms it in a manner consistent with the statute. But given how central that issue is, they might just tell the government to back off. Like, they aren't to be doing this, and this is not what the OIC powers are for. Or they could rule anywhere in between. But ultimately, the buck stops with the court, and there's a whole bunch of ways they could go with this, even if we do receive a favorable ruling. So even if we do win, there are different levels to winning in this case. But it also doesn't have to be a blanket ruling. Like, for example, they may find that some parts of the OIC can still stand. For example, the parts of the OIC which prescribe firearms greater than 10,000 joules may not be subject to the same statutory limitations as the other more generically listed assault-style firearms, because the fundamental reasoning behind those two types of bans are fundamentally different, or supposedly different. Not that they are, mind you, but the courts might come to a ruling like that. But we also shouldn't count our chickens before they hatch. I am certainly no lawyer, no legal expert. It's entirely possible that maybe the justification argument actually does make some sense. I can't imagine how, as seeing that the government's lawyer wasn't ready to present it after 5 years of facing that very obvious question, but who knows, maybe it is. It might also be that the judges won't apply the idea consistently. Like, they might make the mistake of saying that requiring justification and reasons for the decision, it actually makes sense, but that doesn't change the fact that the government doesn't have to explain itself, so no adverse inference can be found. Again, I'm not sure how they could reason that with themselves, but Injustice Kane's ruling was also lousy with contradictions. But still, that was a very fortunate turn of events for us before lunch on day 2 of the hearing. And what was Justice Mactavish doing during this whole time while the other 2 justices were getting to the bottom of what that very important question was? She was tossing softballs to the government lawyers. Like, in the Rias, it says that these newly prohibited firearms are not suitable for civilian use, but in the statute, the threshold is reasonability, not suitability. So she asked what the reason was for this, or she should just consider it to mean basically the same thing. Now, for what it's worth, it's actually really not a bad question. It's a pretty astute observation and criticism if she actually meant it. However, she also supplied her own answer for it, and then the government lawyer just kind of agreed with her answer. Like, it kind of felt like to me she noticed she was being noticeably less critical than the other 2 justices, and then she just came up with a filler question. And again, it's actually not a bad question if she meant it, but it becomes meaningless when you're giving out your own answers to your own questions. And frankly, that was about the harshest question she put forth to the government all day long. And then not much else of significance happened before the lunch break, but apparently during lunch, everyone's favorite Scotsman, Chad lawyer Eugene Meehan, he brought sandwiches for Tracy Wilson and the rest of the gang. Not legally relevant, but just seems like a pretty swell guy, and I wanted to point it out. After lunch, there was one more presentation, and then each applicant got about 10 minutes to make rebuttals to the government's case. And the last presentation from the government was kind of strange. She mostly spoke to the issue of variance and why it was okay for the word variant to be used in the OIC to ban firearms. And a lot of that focused around the fact that the word variant has been used for a long time in firearms law, but it's also been used in a great many other statutes across Canada at all levels of government. Like, it's not an especially rare thing, and she provided ample evidence to this effect. To which I say, okay, fair enough, that's a pretty good argument. But the kind of evidence she provided was very odd. She spent like a quarter of her time covering dozens of statutes from all areas in Canada on all sorts of topics, but I don't think she was proving the point she was trying to prove. Like, she would read out a statute from a particular jurisdiction and then show how the word variant was being used in that jurisdiction for that topic for that statute. And then she pointed out the corresponding definition that was used for variant in each of those statutes. It even got to the point where she read out some municipality in BC, if I remember correctly, where they had like a citywide ban on pit bulls. And speaking of Chad lawyers, this mention was not lost on him, so more on that in a minute. But in that bylaw, it said that they had banned pit bulls, as well as any variant of a pit bull. And then it said that a variant of a pit bull was basically any dog which had a certain amount of pit bull blood in it, or any dog which physically resembled a pit bull, and it even went so far as including nonsense criteria such as certain colors of dog hair in this definition of variant. So, for some reason I really don't understand, in attempting to prove why it was okay to use the word variant, she decided to show the court dozens of examples of all of the way the word variant is defined in all of the other regulations and bylaws across Canada, which is very clearly different from the current circumstance. Like, it was a very bizarre choice of strategy, to say the least. Like, I honestly, I couldn't believe what I was hearing. And unfortunately, I also couldn't tell one way or another what the justices thought about all of this. They seemed fairly silent on what was being said about this particular point. But hopefully it occurs to them that she demonstrated that the word needs to be defined, rather than all what they could have heard is that the word can be used. Like, the use of the word is not exactly the issue here for the applicants. The lack of the definition has always been the issue. And for some unknown reason, the government's lawyer decided it would be a good use of her time to demonstrate how much of an anomaly that actually is in Canadian law. But either way, it was nice to see the wheels coming off of the government's wagon as they wound up all of their presentations at day 2. And then, after the respondent was done, we had the rebuttal from the applicants. And this was a few minutes from each applicant to respond to the various points that were brought up in the presentations from the respondent. Now, for what it's worth, I was actually somewhat dissatisfied with the overall approach that our applicants' lawyers took on this front. For the most part, they appeared to spend most of their time just reiterating condensed versions of their original arguments, which is fine, like it helps to leave those ideas in the minds of the judges as they leave court, but I felt like in some ways it kind of missed the point. Like, this really should have been their opportunity for a counterpunch, and I felt like they maybe missed out on that, despite the fact that a lot of nonsense was said by the government and their lawyers. Like, it should have been very easy to just absolutely pick them apart. And I'm going to do a follow-up video where I detail some of these openings left to us by the government, and some of the things I would have liked to have heard from our applicants. But there were 3 notable rebuttals which I think they did a pretty good job on. And these came from the CCFR's lawyer, Sarah Miller, from the Chad Scotsman, Eugene Meehan, and from Arkadi Bouchelev. Now, Sarah Miller was clearly in better shape on day 2 than she was on day 1. Whatever illness she had was no longer getting the better of her. She appeared a little taller, a little louder, and a little prouder. And one of the things that she rebutted was the evidence of the Henderson precedent. I didn't really cover it in this video, but I did in part 1 of the series if you want to take a look at that. Anywho, there is legal precedent in the Crown versus Henderson, where the courts had to make a determination of the firearms classification over the dispute of whether or not it was a lawful firearm or a prohibited variant. And this dispute long predated the 2020 OIC. Henderson disputed the idea that his firearm, the AP-80, was an unnamed variant of an AK-47, which was a prohibited firearm at the time. He won his case initially, but then lost when the government appealed it on the grounds that it was in fact an unnamed variant of a named variant of an AK-47. Yeah, fun time to be a firearms owner in Canada. But I'll probably talk a little bit more about that in my next video. But Sarah Miller said that that precedent shouldn't be relied upon too heavily by this court. And she actually had a kind of interesting reason for it. She pointed out that the legal question at hand in the Henderson case was actually a Section 74 challenge under the Firearms Act. It was not a Section 7 charter challenge. So the question the court had to answer was fundamentally different. It doesn't actually even attempt to address or engage 7 Sections Liberty Clause or the constitutional issue of vagueness. Now, I don't know what the courts might make of that, but I thought it was an interesting point to bring up nonetheless. And after Miller, we once again saw Eugene Meehan take the stage, and if you remember, he spent most of his time on day 1 discussing the issue of the word variant. And he had the same observation I had when it came to the government's final lawyer. He pointed out that the only dispute was the fact that the word variant remained undefined. His only request was that the government defined it, and that really shouldn't be an inordinately difficult task to pull off. And he even specifically pointed to the presentation made by that final government lawyer, where she showed how the government could even define what a pit bull was, what a variant of a pit bull was. And then he said that even he would have a hard time dreaming up a definition for that. That clearly it would have to be far easier to define what a variant means in respect to firearms. And then lastly, we heard again from Arkadi Bouchelev. And he had an interesting viewpoint regarding the changing of the statutory wording from commonly used to what it says now, which is reasonable for use. And contrary to what the government's lawyers suggested, that changing the standard from reasonable to use instead of commonly used somehow offers less protection for firearms owners, Bouchelev insisted that the new iteration actually provides more protection over the older statute. Before, you had to prove that it was actively and commonly being used for hunting or sporting purposes in Canada before it would gain protection, whereas now you should only have to prove that it is reasonable for hunting or sporting in Canada, independent of whether or not it actually is being commonly used for that purpose. Unfortunately, that argument doesn't exactly have any teeth, so it'll be kind of entirely up to the court for them to decide which way that interpretation should fall. But if they view it in the appropriate context, that this statute exists to protect lawful and honest firearms owners, they should also hold the view that this is meant to be interpreted in a manner which offers more protection and not less for us. And that was essentially the end of it. 2 days of back and forth from both sides. As you can see, I think there are plenty of informed reasons to be optimistic that we should receive a favorable ruling from the court. But it's also plenty easy to buy into the pessimism that goes around as well. Like, the more I look into Canadian law and constitutional law and precedents and everything else and so on, the less and less faith I have in the courts and the legal system in Canada. So when I say I think we have a decent chance to win here, I want you to really understand that is not blind optimism. It's also the reason I made a point of reporting not just what was said at court, but also reporting about the impressions that the judges were giving off. Because as much as anything, that's the indicator as to why I think we can win this time around. Like, while reading Injustice Kane's ruling, it was pretty obvious that she either didn't understand or didn't want to understand the points that the applicants were trying to make. And that was very clearly not what was happening this time around at appeal. At least 2 of the judges were completely on board and understood several of the key arguments being presented to them, and particularly as it related to the ultra vires claim. Now, whether or not they will end up agreeing with these sentiments in their ruling remains to be seen, but I don't know how they can justify ruling against us when the government's own answers to those questions were often downright awful. As for when we could expect to see a ruling, there is really no way to anticipate that. Kane's initial ruling took a little over 6 months to come back, but that was also a much more involved discussion and ruling, so therefore it should have actually taken dramatically longer. That being said, we're already coming up on 4 months now, and I doubt we'll see any kind of ruling announced during election season. Either a positive or a negative ruling could very easily change the outcome of the election if the race is actually as close as the polls appear it to be. However, if the judges do find themselves intentionally delaying the ruling for that reason, I hope it occurs to them of the obviously political nature of this OIC, and hopefully that factors into their ruling somewhat. I've already touched base on this a little bit, but I'll put some information on screen here regarding the various ways the court may rule during judicial review. And as you can see, even if we do receive a favorable ruling, there are a multitude of ways this could play out at the discretion of the court. Like, even if we win, our win may not look like what we expect it to be. But there's really no way to speculate as to what form that might take, given how much discretion with which the court has to rule. But win or lose, this doesn't necessarily mean the end of the case either, as there's always the Supreme Court if it wants to have the final say. That being said, it is actually fairly rare for cases to go to the Supreme Court of Canada. Most of the time, the Federal Court of Appeal ends up having the final say regarding a particular case. And that is because the Supreme Court of Canada actually gets to decide which cases they want to hear, and they may not want to hear ours if we get shot down again. But if they do, some extra arguments can be open to us. Like all of the other stages of court are bound entirely by precedent. But the Supreme Court is not. It can set new precedents and override previous precedents if need be. Not that they do that often, mind you, but they can. So for example, the Bill of Rights arguments presented by Saskatchewan might have more bite in front of the Supreme Court than it did this time around. And in the next part of the series, I'm going to go over some of my own ideas and arguments in the event that it might actually get that far. All that being said, I'd like to thank you all for watching, and we'll see you in the next video.